IA for withdrawal has been filed by us as our grievances have already been redressed in view of the order that has been passed by the
I'm
respondent.
not saying your file IA for withdrawal. That stands for me. When is the respondent released?
I will check.
You informed them, right? Mr.
Uh,
Jain, Franklin, Toki.
I will talk to him.
Please inform them.
Yes, sir.
Any adverse matter against you? Nothing. No. With the WPS number 4860 of 2019. With WPS number 4862 of 2019. When it comes to for the petitioner, submit that into 50 application number 1082923 and 1082823 has been filed in WPS number 4860 of 2019 and the WPS number 4862 of 2019 respectively seeking withdrawal of the present case. She submits that the petitioners do not have any surviving grounds. Considering the aforesaid submission, IA WPS number 4860 of 2019 and WPS number 4862 of 2019 are dismissed as withdrawn.
Much obliged.
For Canada Storage Item 1, CRMP 694 of 2011. Yes, long item 2 to 4.
There are
And your
altogether,
IA for
I have filed in 3 matters.
चौथा का क्या होगा?
चौथा, because once Mr. Ashok Kuyal came, but Lakpat Bhaijan had not come. That is the चौथा नहीं file कर पाया. But I have filed the supplementary affidavit. I am just submitting that I have filed the
In both the cases, both of them are supposed to come.
Yes, both have.
तो एक
Or
का
only because of some health issue, one Mr. Ashok Kejriwal could not reach to the Ranchi Road because of this sugar. But I have filed the supplementary affidavit wherein I have annexed the Jhalsa report. In Jhalsa, both of them were put. And in 3, I have filed the ID.
आपका जितना मैं आईए फाइल किया उतना ही विड्रॉल होगा बाकी तो आपको फाइल करना है कौन सा मैंने फाइल
Ashok Kejriwal. CRMP number 1272 of 2011.
1272 of 2008
11.
why have you not filed in one of the cases
He's not coming. Oh, sorry.
he's not coming
No.
Acha, the other side was not there. Some difficulty of
Some
logistics.
difficulty.
But it is there in the Jhalsa records. What's the entire agreement is? We have filed by way of an affidavit.
so what all are the sections
This was in which case you not this case 141.
384
384 there is a judgment.
but in one more case you should file your formal petition
Actually, we are ready minutes. My client will come. The other side is bit.
who is the other side?
Rajpat Bhajan ka is informant. The lawyer is Abhay Prakash.
Where is he now?
Abhay Prakash is here. I don't know. Probably under the impression that it is
When
not.
he comes there yes Mr. Abhay Prakash you are not interested in filing your petition in one case you are not filing
Yeah, Lordship, actually his client was not present on that very day. He was approaching through a barrier. That was the reason. That was the reason we have. Yeah, Lord,
अच्छा
Lordship,
दोनों गुजरात का है ना सो वहाँ पे एफिडेविट करके दाखिल एक्सेप्ट हो जाता है वही करा लेते हैं
only in the one case, he was there, present in there. He came from Gujarat for signing this document itself. But his client was not there, that's why it was not seen. हाँ लाजपत भजन का. He has already signed.
ठीक है मैडम, electric will adjourn for 2 weeks. We'll talk and get it done. 2 weeks or 3 weeks?
Council, for the
हाँ,
parties
3
are
weeks कर
present,
दीजिए. हाँ.
they submit that in these cases, can we dispose of that?
Yes, yes. 3 cases, other 3 cases can be disposed of. Why keep all the 3 other 3 pending?
Can we
Yes,
dispose
yes,
of the
yes.
three in which you are not filed?
We have not filed our thing in this one. इसमें नहीं filed हुआ है. 1 to 70. 1 to 70.
Yes.
We'll do it together.
Your Lordship.
They submit that out of the 4 matters which are listed today, joint compromise petition has been filed only in 3. And they submit that the joint compromise petition in judgment in
Well,
CRA
1272. 1272 of 2011. Ashok Kejriwal.
1272 of 2011 will be filed shortly.
Lordship.
They jointly pray that the matter be posted on 8th of February का public.
January or in the last week it's
नहीं,
feasible,
actually इसको
Lordship.
2nd February कर दिया.
Second fact.
On 2nd.
Lordship. Yeah.
ये सारा
और
judgments आपको
हाँ,
provide
है,
करेगा।
है. दे दे अभी.
What all sections are?
हाँ, 387 is also, 384 is also. 307 is also. सब कुछ. The only test is whether it involves any public interest or not. That is the test.
Public element.
A public element. If it is private, arising out of some commercial dispute, otherwise also has some 307, 384 Supreme Court.
हम लोग भी किए हैं।
हाँ,
इसमें किए हैं।
This one case पे हुआ है.
related with this.
In one case, yes. What is there?
एक matrimonial dispute है।
मैट्रिमोनियल तो करना ही चाहिए. सुप्रीम कोर्ट
307
हाँ, अगर 307 आजकल लगा देता है.
Item 5, WPS 6497 of 2016.
Yes.
My lord, last occasion, supplementary counter affidavit has been demanded. They have filed and I have submitted my rejoinder also for that. Matter relates with the dismissal of.
Supplementary affidavit, you want to file a response to that?
I have submitted rejoinder also.
You have filed your response also?
Yes.
You have filed your written notes?
No, Lordship, written. Lordship, order was for supplementary counter affidavit.
For separate things, separate orders.
It will be filed, Lordship.
Yes, you are. What is your prayer in the report?
My prayer, my lord, I have been dismissed second time for the same cause of action. First dismissal was quashed by DGP and he has instructed to conduct the fresh inquiry on certain points. The complainant must be examined and his accounts. There was a allegation against my petitioner, theft of 9,000 rupees from his bank. Annexure 2, my lord, page 25, if I permitted to read. That will make it clear.
No, let us see what all orders you are challenging.
My simply second
Earlier dismissal order was set aside. No?
set aside by
Why do
DGP.
you say for the second time same?
Second time again the inquiry officer has found no guilty. In the meantime, after submission of the inquiry report, disciplinary officer has changed the IU, inquiry officer, and he has get accordingly within a very short period. No second opportunity was given to me, and no accounts of the persons of the complainant had been examined. DGP has clearly instructed, he examined the accounts of complainant, whether he has drawn the money from his bank or not, before keeping in the bank. He told before the preliminary officer that I have drawn the money from bank, and that money 9,000 was kept with one Ramnan Singh. Ramnan Singh was not examined by the IU. My inquiry officer
Where is the charge?
charged my lord.
Where is the charge?
I have given first inquiry report.
Where is the charge?
चार्ज उसी पर जब डिस्मिसल हो गया तो सेकंड नो विदाउट इश्यूइंग चार्ज शीट दे हैव स्टार्टेड अनदर डिपार्टमेंटल प्रोसीडिंग.
They must have once.
No, they have
once
they have
the
issued
DG
first charge,
had asked for fresh inquiry.
but they have not issued another charge.
Need not. It will be done on the same charge.
Same charge. My lord.
Where is that charge?
I have a next only the question order of the DG.
Very good. Where is the charge sheet? Which is the foundation of a DG.
Definitely, my lord, I could not get up till now from the customer.
You know, your client doesn't have.
No, charge I have not got, my lord. So I have not filed. If I permitted, then I will obtain
How
from
the
that.
departmental proceedings
Matter is very important.
The charge
Charge sheet is very important, my lord. I agree, but I could not get, my lord.
Counsel
I
for the
will-
parties are present. Counsel for the petitioner seeks
एक बार
time.
तो सेट असाइड हुआ, my lord, उसी पर चला.
Remitted back what the set aside.
But where is the charge sheet? Unless I see
Oh,
the
yes, my
charge,
lord.
how do I decide?
Right, I agree, my lord. Give me an opportunity. I will ask him to submit charge. Copy of charge.
Will you bring on record the charge sheet?
No, he has not given.
He has not given.
No.
You file the charge sheet.
Myself.
Your case,
Yes.
you file the charge sheet. Counsel for the parties are present. Counsel for
If
the
I have,
during the course of arguments, it transpired that the charge on the basis of which the departmental proceeding was initiated against the petitioner is not on record. Counsel for the petitioner prays for time to bring on record the charge memo, which was the foundation of the
right.
entire departmental proceedings. Post this case on
So वो पटना में रहता है, all is there.
19 January.
ठीक है,
Okay. The supplementary affidavit annexing the charge memo should be filed by 17th.
I will file the written also.
You also.
Appearance.
You have given in the copy of the written notes? Have you given in the copy of the written notes?
So I give it.
In the charge memo of the departmental proceeding cannot.
Definitely. I feel.
Item 6, WBC 2560 of 2021.
matter related to refund of money given to the government authority in respect to obtain a tender. That tender has not been fulfilled. Advance amount has been given. Meantime, work order has to be given by the government. That has not been given due to pandemic or any other reason. Because when formality has been completed, the pandemic has come. And it was related to flying of the bus and collection of taxes from bus estate. March 2000.
Where is the notice which is under challenge?
Notice when government not fulfilled the formality of tender, then he issued a notice upon me that I have gone to extend the period of tender for further 5 months from expiry, and you have to accept this. So my submission is that after expiration of the period for 1 year, he tried to extend the period for next 5 months. Even first contract had not been completed. I was successful bidder and tender has allotted to me, advance money has been given, but work order has not been given to me and execution of contract has not been made. So therefore I was not in position to collect the amount, and further pandemic in March 2020 came, therefore flying of the bus.
Give me the list of dates. Give me the list of dates and focus on it.
Yes,
They are opposing or they are admitting?
they are opposing. Admitting the fact.
The fact might be, but they are opposing the refund.
Yes, opposing
It
that.
has been forfeited according to them.
No, not forfeited. This is my submission also. Till date, amount
Where is
has
the
not been
respondent?
forfeited.
And where is your list of dates?
I have filed the written argument too, but date list with my synopsis also. Before synopsis, list of date is there.
Is that sufficient?
I may file a fresh list of dates also on date of the yes. But all the details have been given also.
The contract was for what purpose?
For collection of taxes in bus stand. वो जो बस के
What tax?
हाँ बस स्टॉप में जो कमीशन लेते हैं वो that is issued in tender and that tender he purchased he has taken for 1 year and for that 1 year execution has not been made and work order was not issued to me and
What is the date of tender?
let's see. That is
You have to give your list of dates properly. Your synopsis is sufficient. We know how do you make the synopsis.
I will supply.
Pleadings are complete.
Yes, please.
Council whether the teacher is present. Nobody appears on behalf of the respondents. The council submits that the pleadings in the present case is complete. He submits that the matter relates to refund of the amount which the petitioner had submitted pursuant to tender, but ultimately no contract could be entered into between the parties.
And work order was
And
not
the work order was also not issued.
issued.
The learned council has submitted that during the intervening period, there was COVID-19 pandemic. He has submitted that through the counter affidavit, the facts are not in dispute, but the respondents have opposed the prayer for since the respondents are absent, in order to give one more chance to the council for the respondents, the matter is adjourned and is directed to be posted on 19th of January. In the meantime, the parties are directed to file their short synopsis, list of dates, and the judges wish this to be latest by 17th January. 17 January तक file next. Even if they don't want, they will do it. Get a copy of this order, get a soft copy of this order, and communicate it to council and
Item 7, Criminal Relent 221 of 2017.
maintenance.
Yes, Lordship, in this case, daughter-in-law pay for maintenance from mother-in-law.
Mother-in-law, father-in-law.
Mother-in-law, widow mother-in-law.
She has ancestral copies.
No.
No.
It's wrong. It is the wrong statement. Wife is not asking from the mother-in-law, rather from her husband, which is joint family.
Property.
Property.
You are representing whom? Afroz
Afroz
Khatun.
Khan.
You are the husband?
No,
Who are you?
I am the mother-in-law.
Afrozi Khatun is
Yes,
the
this is
mother-in-law.
the mother-in-law.
There is a direction upon you to make the payment.
No, there is no direction. The mother-in-law is not a party in a maintenance case.
So how are you agreeing?
But
How are you agreeing?
but order is direction is given to three people. Mother-in-law and two sons gave the amount and distributed the amount, and she asking from mother-in-law.
May I explain? Actually, from very beginning I am doing this. Actually, marriage was solemnized about 20 years back. The husband is having a grocery shop and 2-3 big building, double-story building, and 2 plots. All are joint family, inherited from father. Mother-in-law was not implicated the party in the first case, in the maintenance case. Then when finally nobody could bring the material on record that from which amount the maintenance shall be paid. Because the husband was completely denying that I am not earned. That husband, actually he has 3 children, 3 minor children and wife, 4 dependent. And she was kicked out from the house about 15 years back. So that right from last 15 years the maintenance case is this way or that way going on. Then the fixed amount of rupees 5 lakhs was fixed in the State Bank of India, in which was in the name of this husband and the mother-in-law, 2 names. Then, when the order of maintenance was given, the court simply said that this 5,000 shall not be withdrawn by anybody, and the interest which will be fetched, it will come. The 4 persons shall be maintained from that interest. Thereafter, my lord, I am coming to
That was
this.
challenged.
My lord, I am coming to this. Then mother challenged it. My lord, I am coming.
See, you have so much of history to this litigation.
नहीं थोड़ा 2 minute. Afrozi Khatun mother-in-law, she challenged before criminal division here before this Honorable Court. This Honorable Court said that since she was not a party, and she said it is also my money and son's money and both having the money, so she should be allowed to contest before the trial court, remanded back the matter. Then again matter was remanded, and which is impugned herein, then order was fetched, in which mother-in-law knowingly avoided to appear. Mother-in-law, she did not turn up there because she was said that you go and contest there, I am sending your case back. She did not turn up a single day nor file any show. Husband and wife were contesting there again. Then mother-in-law said, ये हमारे देन महर का पैसा है. But the court said that ये देन महर का कोई भी amount कभी भी.
Where does she? She did not appear before the learned.
She did not, लेकिन वो उसमें जवाब में आया है कि वो उसके बेटे ने लिखा, हस्बैंड ने लिखा कि हमारे माँ को देन महर का पैसा मिला था. तो खैर एनीवे, तो कोर्ट ने उसको इनकार कर दिया. कोर्ट ने कहा कि एक चीट ऑफ पेपर भी नहीं दिया आपने. दूसरा, एक mother-in-law is also pensioner. Her husband was in the colliery on the big post, and she is the pensioner, and entire property is jointly held by mother-in-law and the son. So, my lord, again the same order has been passed by the court, honorable court, that out of 5 lakhs which was fixed.
Where is the earlier order of remand? Where is that?
Earlier order of the High Court. Remand order.
Where is that? Where is the order of remand?
I am giving it. It is here.
It is not annexed in this record.
No, it is annexed. Petitioner has annexed. बताइए ना कहाँ पर है हाई कोर्ट वाला ऑर्डर. जस्टिस का है. गुप्ता साहब. Now it starts from page number 18. Annexure 1.
Madam, why your client did not appear before the
My lord, one thing, 2 minutes more, my lord. There she did not contest there. The court again, my lord, then again he left the court. Husband left the court. Did not. जब कोर्ट ने कहा कि पैसा दो तो किसी भी तरह से तो जमीन बेचा है 25 लाख का, एक 12 लाख का, एक 13 लाख का, हम लोगों ने डॉक्यूमेंट फाइल कर दिया, वो है रिकॉर्ड आया है। और एक बिल्डिंग है जिसे 10,000 रुपया पर मंथ मिलता है और ग्रोसरी शॉप से 20,000 रफली उनको मिलता है। ये सब उनकी अपनी आमदनी है हस्बैंड की, और रहते हैं ज्वाइंट फैमिली माँ के साथ। तो कोर्ट ने कहा कि भाई आफ्टर ऑल जब नहीं दोगे तो एक चीज़ तो है जो बैंक में पैसा है, तो उसी पैसे से अगेन।
That's your petitioner. Yes, what is your grievance? How do you assail this order? You are in a divisional jurisdiction. Show me some error of jurisdiction or gross irregularity or illegality in the order.
Lordship, that the amount of interest occurred and being occurred from 5 lakh rupees being deposited in STDR account, Lordship. Paid to all the petitioners. This is the judgment. So, and since the three children of the appellant number 1 or copy number 1 are minor, but now they are major. One daughter is only minor.
Most of them have become major, right?
Yes.
And they are
One
ceased
is
to be dependent. They are
No.
not dependent anymore.
No.
They are independently
Yes,
earning.
yes.
18 साल का है तो independent।
Entire to draw the full amount of the interest occurred upon rupees 5 lakh fixed STDR number such and such with the SBI bank. The bank is directed to pay the interest thereon. It was made clear that the principal amount of the said fixed deposit shall not be allowed to be in cash by anyone even after its maturity, and it will be renewed from time to time so that minimum benefit of the interest of the same would
That's
be.
what we have read. Yes, sir. So, according to you, 3 of them have become major and only 1 is minor.
2 of them, yes.
Then, they became major during the pendency of this case.
Yes, now, that time they are not major. Now they are major, and they are working and earning lots of money.
So they are independent.
Yes.
You have a provision under law for modification of order. You go there. That will not make the order illegal. And you see, this order of maintenance will relate back to the
15
date
years
when it
back,
was
not a
filed.
single penny has been given.
To the date it was filed.
Yeah. Not a single penny till date has been given. And they are evading arrest. Husband is evading arrest.
The mother-in-law is a old lady, ladyship.
Therefore, she should all the more make the payment. Marriage is not in dispute. The children are not in dispute. What is this? You will take your money when you die. Mother-in-law will take the money to the heaven.
The money is 5 lakh is the den moher. The den moher is the mother.
But the mother-in-law never appeared before the learned court. After the order of remand, she did not appear. Criminal division number 221 of 2017. For the learned counsel for the parties, this revision has been filed against the judgment dated 24/11/2016, passed in maintenance case number 70 of 2009, passed by learned Principal Judge Family Court, Kodarma. Thereby, following direction has been issued. Ordered page number 56. The learned counsel for the petitioner, by assailing the inquiry, has submitted that the amount which was fixed as STDR in her name
There are two names
In the name
of the petitioner as well
petitioner
as
and her son.
the husband son.
Two
And
sons.
That who is the husband?
One is the husband of this opposite party
Petitioner
member.
and her family was the amount of then mohr, and no maintenance would have been awarded with respect to any interest or the amount of STDR accruing on the same, right? The Learned Council has submitted that. The applicant had filed the application on behalf of herself. Applicant wife had filed the application on behalf of herself and 3 minor children who have now become major. Out of them, 3 minor children.
One minor children or two major. 3 children.
You know the-
3 बच्चे होंगे.
3 children.
When the dispute arises, 21 years is the
Please hold
age.
on, please.
Abhi 21 bhi nahi hua.
Sir, please hold on. Out of them, 2 have become major and they are earning pretty well. And therefore, maintenance granted to major children cannot be sustained in the eyes of law. However, during the course of arguments, the Learned Counsel for the appellant, the petitioner, has submitted that the 2 children who have become major, the 2 children have become major during the pendency of the present case. The Learned Counsel, appearing on behalf of the opposite party, has opposed the prayer and has submitted that the petitioner had earlier moved this court in Criminal Division number 639 of 2011, which was disposed of on 27/11/2014, and the matter was remanded back to the Learned Court below for passing fresh order. The application was allowed on the ground that the petitioner was not made party in the maintenance case, although STDR she was the joint owner of the STDR. The Learned Counsel submits that after the order of remand, the petitioner did not participate in the proceedings and fresh order was passed. And therefore, there is no illegality in the impugned order, which does not call for any interference. He has also submitted that the case of maintenance was filed as back as in the year 2009, and not even a penny of the maintenance has been ultimately come to the applicants of the maintenance case.
Till date, nothing single penny.
Not sure. उस मैंने डॉटर इन लॉ के पास ने वो लिया है 12 लाख रुपीस उनसे ले लिया है. वो 3 प्लॉट दिए थे तो बेचा था उन्होंने 12 लाख रुपीस दिन मोहर में लिया है.
You did not participate in the proceedings. Who is going to take care of this? After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the fresh order of maintenance has been passed after the matter was remanded to the Learned Court below for fresh consideration at the instance of the present petitioner, who has filed Criminal Division number 639 of 2011, and the said case was disposed of on 27/11/2014 with the following directions. It is not in dispute that the petitioner thereafter did not appear before the Learned Court below, and ultimately the Learned Court below has passed fresh order as quoted above. This court has gone through the impugned order and the same is a well-reasoned order considering every aspect of the matter. No illegality or perversity as such has been pointed out by the learned counsel for the petitioners seeking any interference in the impugned order. So far as the point that the amount of STDR was a part of their mohar is concerned, the same is essentially a question of fact. And the petitioner, having not contested the case before the learned court below in spite of remand, cannot raise such an issue. So far as the case of the petitioner that the two dependent children out of 3 of the applicant have become major and they have good source of livelihood, this aspect of the matter also cannot be agitated in this revision jurisdiction. The petitioner has a remedy in terms of section 125 within bracket 3 of the Code of Criminal Procedure for seeking appropriate relief before the learned court. The matter has remained pending before this court since 2017. Stay with them.
Stay. Bank amount stay.
कोर्ट ने अभी जो इम्प्यून ऑर्डर है उसमें बड़ा लड़का 16 साल और लड़की 13 और 12, तो अभी ये मेजर पर लिखवा रहे हैं सबमिशन पर रिकॉर्ड में इम्प्यून ऑर्डर में पैराग्राफ 11 में.
The interim order is hereby vacated. This revision is accordingly dismissed.
May I request note,
Also for the state as opposed to the
subject to your lordship pleasure, the SBI, the concerned SBI may be directed that we file application.
Why should I give direct distribution? Okay,
अभी मतलब in between the period there was no order in her favor, even then they are not giving money from right from very beginning.
Go to the executing court. Go to the executing court.
Yes.
They will make SBI a party and proceed against them.
Item 8, Criminal Vision 1118 of 2017.
This is a case in which the father-in-law, petitioner is the father-in-law, who has been saddled with an order of maintaining his widow daughter-in-law by adopting section 19 of the Hindu Adoption and Maintenance Act. This is the question of law which is required to be.
The provision is very clear.
The provision is very clear, Lordship. That is what I want to place before your Lordship. The provision says that only from the property and co-personary property from which no share has been obtained. What हम लोग पढ़ रहे हैं? Hindu Adoption and Maintenance Act, section 19.
Here for the
Yes, private respondent. मुझे पढ़ते हैं. A Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law, provided and to the extent that she is unable to maintain herself out of her own earnings or other property, or where she has no property of her own, is unable to obtain maintenance from the estate of her husband or her father or mother. B, from her son or daughter, if any, or his estate. 2. It is very important and it is applicable to my petition. An obligation under subsection 1 shall not be enforceable if the father-in-law has not the means to do so from any co-partnership property in his possession, out of which the daughter-in-law has not obtained any share, and any such obligation shall cease on the remarriage of the daughter-in-law.
Any obligation on a substance shall not be enforceable if the father-in-law has not the means to do so.
From any co-partnership property in his possession, out of which the daughter-in-law has not obtained any share.
What does that mean?
It means that there should be a co-partnership property, and out of that co-partnership property, the deceased or the husband of the widow has not obtained any share, and that property is still with the father-in-law, and from that property only maintenance can be allowed to the widow. It means. So in my case, Lordship, in course of the argument before another bench, Lordship, once my Lord had said that you saw that there is any co-partnership property with you from which any share has been given or not given. तो हम लोगों ने एक सप्लीमेंट्री एफिडेविट दिया
देखिए यहाँ supplementary नहीं चल रहा है।
नहीं हम लोग दिए थे वो हम लोग फैक्ट
जो वहाँ पे किए हैं बस उसके beyond कुछ नहीं।
हाँ तो उसके बियॉन्ड हम नहीं कोई जाएंगे खाली सिर्फ और सिर्फ लॉ ओनली लॉ
You're not entertaining of
यस
it. My-
तो अब इसके बाद क्या होना चाहिए सबसे पहले तो जो डिस्कशन होना चाहिए कि देयर
Can
वाज
you see the findings?
there is no finding with regard to any co-partnership property which is in my possession and from which I have not given any share.
Let us see what was your case, my lord. In this case, my lord, OP number 2 का हस्बैंड जीवन लाल 2010 में देख कर गया my lord. उसके बाद वो इन लोग सास ससुर उसको टॉर्चर करके उसको घर से निकाल दिया. उसके बाद वो तीन माइनर गर्ल्स के साथ.
Property, is it ancestral property? The
Yes,
house
ma'am.
is an ancestral home.
ये हमारा जो पिटिशनर थे रेलवे में नौकरी करते थे क्लास 3 का पोस्ट थे
I
अपने
just want to know.
नो देयर वाज नो एंसेस्ट्रल प्रॉपर्टी देयर इज वन प्रॉपर्टी 8 डिसमिल या कितना जमीन था जो हम से लाए
In
हैं
whose name?
हैं
In whose name?
मेरे फोर फादर के नाम से था उसमें से करीब कितना मिला है सो हम एग्जैक्टली बता दे रहे हैं
किसको?
हमारे हमको माने हम फादर इन लॉ है हमको करीब 1.5-2 डिसमिल जमीन मिला है जिसमें मेरा घर है
उसके साथ में रहती थी.
That is a matrimonial home.
Yes.
दैट इज मैट्रिमोनियल हम
She has a right to live in that
Yes, right to
matrimonial
live,
home.
right-
Irrespective of the fact whether you give her anything or not, she has a right to live
right
in
to
that
live that has been denied by the lower court only maintain 20D by 20D of the domestic violence act का उसके तहत उनको 3,000 रुपए मेंटेनेंस दिया गया
मॉनेटरी रिलीफ के लिए.
हाँ 20D में दिया गया
और ये सीजीएम क्या फाइल की थी एडिशनल सेशन जज भी दोनों उसको माने
कर
कि
दिया।
3,000 रुपए इसको देना चाहिए. और 3 माइनर चाइल्ड और लेडीज को घर से निकाल दिया गया माइनर. और वो अभी दाई का काम कर रही है. अब मोटर व्हीकल एक्ट में पैसा मिला था तो माइनर इसमें सास ससुर दोनों ही लिया था उसमें.
Read the appeal order.
Yes, हुजूर इसमें जो मैजिस्ट्रेट का ऑर्डर है उसमें ये एक इशू बनाए थे इशू नंबर 5
Where is your stand before the where are your petitions filed before the domestic violence?
Yes.
Where is that petition?
Annexure.
You have annexed it?
Annexure, yes, Lord.
Where is your petition and where is the petition of the wife and the declarant?
जो Annexure 2 है जो
Annexure 1 is the
हाँ
application.
जी Annexure 1 है जो सेक्शन 12 में फाइल किया गया था वाइफ के द्वारा विडो के द्वारा पेज 27 से शुरू है हुजूर
And where is your reply? Where is your reply to
Yes.
this? Where is your response to this petition? Where
response response lower court में response नहीं लगा हुआ अभी lower
You
court
did not file a response.
फाइल हुआ था लेकिन इसमें शायद लगा हुआ नहीं है
File it.
yes
उसी में का सब कहानी होगा.
no
You are making a new story over here.
no I am not making any story all the story is
We
in
will
black
see
and white in the
We'll
interim
see
order
it from your petition.
yes
Criminal Division number 118 of 2017. Counsel for the parties are present. Counsel for the petitioner submits that although the application filed by the opposite party before the learned court below has been placed on record, but the response of the petitioner is not on record of this criminal division. The petitioner is directed to file a supplementary affidavit bringing on record the response filed by the petitioner before the learned court below to the application filed by the opposite party. Post this case on 19th, the supplementary affidavit should be filed by 17th of January.
We are posted.
Order Second 9, Criminal Division 440 of 2017.
So kindly see the order dated 10th of November 23. Because I was directed to, I had offered for one-time settlement, and I was directed to pay the sum of rupees 2 lakhs, which shall be adjusted from the final amount so arrived at in course of settlement.
No, Your Lordship, wife is not ready for 15 lakh, Your Lord, is 25, his offer is 25. I have been directed by the court, Your Lordship, to take instruction from the wife that she is ready or not. He is ready for 25 lakhs, Your Lordship. After adjusting the 22 lakh, 23 lakh, if he ready to give, then
What is the due note?
Due order is
10,000.
10,000. Been directed to pay 10,000
from 2014.
to the wife.
What is the total amount? It comes, what is the total calculation? You wanted one-time payment
One time.
inclusive of the arrears?
Yes.
How much is the amount constituting the arrears?
Well, I have to calculate.
7 or 8 lakh.
In the meantime, some payments were made.
After deducting, Your Lordship, 7
Divorce
or 8.
has happened?
No.
So.
They have been
it is
residing separately.
5,000, sorry, it is,
So there was a matrimonial suit in which I was directed to pay under section 24. I was directed to pay 5,000, but that matrimonial suit has been dismissed for default, and thereafter no steps were taken for restoration of the suit. So
they are asking for 25 lakhs, are you interested?
I will seek inside, but my personal interaction with him, I don't think he's in a position to pay that. He's a doctor employed with Ramakrishna Mission Tuberculosis Center.
So they don't pay you?
The salary which we have attached, it is 19,000, and in hand he was getting that point of time
He's
15,000.
getting less than the minimum wages also?
He was getting 15,000. Whereas I have enclosed, that was of course in 2013. The salary slip which we have enclosed with the,
Minimum wages is more than whatever you are saying.
it must have increased to 30,000, 30, 35.
I don't have any idea, but the amount that you are saying for a doctor is less than minimum wages.
But it's there on record.
And apart from that, maintenance is required to be paid. Even you want to get rid of this maintenance amount for all times to come.
What we had proposed in
Otherwise, you see, this will go on.
yes,
This will go on for your lifetime.
what we had proposed, me and my learned
You
friend.
have proposed 15 lakhs.
No, we had interacted with the
Inclusive
client.
area.
We had interacted with the client and both of us. And his offer was 15 lakhs that point of time. But we had initially my friend will also agree. He was initially offering 10 lakhs. I had only asked him to increase it to 15
I'm
lakhs.
not agree.
नहीं, पहले 10 होगा था, आगे से
नहीं,
चेंबर में-
हम नहीं करें, हम कैसे एग्री हो सकते? तो
We will see
इंस्ट्रक्शन
only by the order sheet.
Yes,
Right?
make
Petitioner
an
is ready to pay 15 lakhs towards full and final settlement.
yes.
2 lakhs you deposited.
Yes.
You want to go for mediation.
I can ask.
And he is not ready to give any Stri Dhan also, Your Lordship. He has said that no ornaments is
That
here.
is why, that is why.
Yes, Your Lordship.
You want to go for mediation, you talk to your client, go outside and let me know. Then I will send
Why
you.
are you to send it for mediation?
Sorry? No, I have to record your consent. No, yeah, you have to talk to your client. You cannot send matters for mediation. Just go out and talk to your clients. We'll send it for you.
Yes, Your Lordship. After 10 or 15 minutes.
Yes.
But it's passing it.
I have taken his instruction.
At 10-15 minutes.
Yes, sir. I have taken instruction.
3:30 you come back.
Yes.
Item 10, Criminal Division 1260 of 2017. Along with item 11.
Yes, what is it? Yes,
In this case, my lord, we have filed revision.
you are the petitioner.
My lord, in one case, Basruddin Khan is petitioner. There are two cases, my lord.
Yes, tell us. This one?
1262, I am petitioner.
Where are the other two cases?
Y524
They are listed?
टैग किया हुआ है एक साथ
Yeah, okay.
10
It is arising out of common law?
yes.
Why everybody is agreed with that? What is
Actually,
the,
trial court has convicted the accused person. Then appellate court has confirmed the conviction order, but given under section 4 of the provision of Offender Acts, they have been released.
so
That order has been challenged by the informant.
that order has been challenged with the informant? Who is the informant? No.
Yes, yes.
What is wrong with it?
Actually, that provision of Offender Acts, provision of Offender Acts not been followed properly.
Not being followed properly.
Properly.
What is the illegality in the accused order? This is what is not satisfying this.
Yes, yes.
Read the criminal divisional order, appellate order.
Yes. In I am reading from criminal division number 15.
498A.
Yes, 498 and section 3 of the DP Act.
Conviction was there, conviction has been upheld in both the sections.
Yes. I
Let's
am-
read it.
I am
Page
reading.
48. Page 48. Internal basics of
Yes, yes, yes. I am reading from 47, my lord, because 47 the last paragraph as per.
You see, the conviction is upheld.
Yes.
There is no doubt. Now let us see how the
Yes.
sentence is modified.
Yes. That therefore I am reading that paragraph by page 47, last paragraph. As for the sentence awarded by the learned CTM Garwa in this case to the appellant accused to undergo for a period of 2 years RI for commission of offence under section 498 of the IPC along with fine amounting to rupees 1,000 to each convict as well as to go another RI for 6 months for the offence under section 3 of the Dowry Provision Act, and is ordered that all the sentences will run concurrently is concerned. This court finds that to send the convict in jail in order to serve the aforesaid sentence would not meet the ends of justice. It is argued on behalf of the appellants accused themselves that the complainant, respondent, victim, Gulshansari, as well as the appellant accused husband of the complainant, namely Parvez Alam, are now remarried to another person and living separately, having no concern to each other. Therefore, this court feels that sending the applicant accused to jail would not be proper, since the complainant, respondent, Gulshansari suffered mentally as well as physically. Therefore, it is justifiable to compensate her in terms of money. At the same time, the law says that the guilty should not be left unpunished. Nowadays, there is an increasing emphasis on the reformation and rehabilitation of the offender as a useful and self-reliant member of the society without subjecting to them to deleterious effects of jail life. And thus, the probation offender acts is milestone in the progress of the modern liberal trend of the reform in the field of criminology. More so, the modern criminal justice recognizes that no one is born criminal and that a good many crimes are the product of the socio-economic milieu. Hence, this court comes to this conclusion that in lieu of sentence awarded to the appellant accused to go in jail for 2 years and 6 months RI, for commission of offences punishable under section 498 of the IPC and 3 of the dowry provision act respectively, it would be proper to release them under section 4 of the provision of offenders act to maintain good behavior as they are exceeding rigor of litigation since 2006. Thus, the sentence of for 2 years and 6 months arrive for the offence under section 498 of the IPC and section 3 of the dowry provision
So
act.
what is your grievance?
Grievance, my lord?
You are married. You are living separately.
Yes.
What is your grievance?
हेलो
जबरदस्ती जेल में
तुझे टॉर्चर किए हैं तो उसका पनिशमेंट तो होना ही चाहिए and my argument is my
Tell us that what is the illegality?
yes therefore I am maybe permitted to read the section 4 of the provision of offenders act, my lord.
Like probation of offenders act. It is not applicable.
Applicable, yes, but there is such some condition, my lord.
What
And
are
there
the conditions?
condition इसमें लिखा हुआ है
Tell us.
maybe permitted to. When any person is found guilty of having committed an offence not punishable with death or imprisonment for life, and then the court by which the person is found guilty is obtained that having regard to the circumstances of the case, including the nature of the offence, इसको भी देखना है, and the character of the offender, इसको भी देखना है. It is expedient to release. Expedient वर्ड के ऊपर भी ऑनरेबल सुप्रीम कोर्ट को बहुत ज़्यादा जोर दिया है. इसमें expedient होना चाहिए तभी रिलीज होगा. To release him on probation of good conduct, then not to change anything contained in any other law for the time being in force, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties to appear and receive sentence when called upon during such period not exceeding 3 years, as the court may direct, and in the meantime to keep the peace and give to.
So what was it that this?
इसमें हर एक जो प्रोविजन ऑफ ऑफेंडर्स एक्ट में जो दिस 2 में दिया हुआ है, before making any order under subsection 2 is made, the court shall take into consideration the report if any of the probation officer concerned in relation to the case. इसमें probation officer का कोई भी रिपोर्ट नहीं मंगाया गया, my lord, and there is a judgment of the honorable Supreme Court, my lord, in this regard. In this regard, my lord, due to non-following the provision, my lord, case has been remanded to the court below, my lord.
So not having any report under probation of offenders act is the reason that the interim order suffers from illegal.
मतलब कोई भी रीजन नहीं दिया गया कि क्या कैरेक्टर क्या है उनका, कुछ नहीं दिया गया, नेचर ऑफ ऑफेंस कुछ भी नहीं दिया गया. पैरा 23 ऑफ द ऑन द जजमेंट ऑफ द ऑनरेबल सुप्रीम कोर्ट. We have referred to the aforesaid authority to stress the point that the court, before exercising the power under section 4 of the PO Act, has to keep in view of the nature of offence and condition incorporated under section 4 of the PO Act, be stated in Dalbir Singh versus State of Haryana and others. It has been held that Parliament has made it clear that only if the court forms the opinion that it is expedient to release the convict on probation for good conduct regard being had to the circumstances of the case, and one of the circumstances which cannot be sidelined in forming the said opinion is the nature of the offence. The court has further opinion that though the discretion has been vested in the court to decide when and how the court should form such opinion, yet the provision itself provides sufficient indication that releasing the convicted person on probation of good conduct must appear to the court to be expedient. Explaining the word expedient, the court held thus: the word expedient had been thoughtfully employed by Parliament in the section so as to mean it as apt and suitable to the end in view. In Black's Law Dictionary, the word expedient defined as suitable and appropriate for accomplishment of a specified object, besides the other meaning referred to earlier in State of Gujarat versus Jamandas G. Public in a 3 judge bench of this court has considered the word expedient. Learned judges have observed in para 21 thus. Again, the word expedient used in this provision has several sets of meaning. In one dictionary sense, expedient means apt and suitable to the end in view, practical and efficient, politic and profitable to investment, proper and suitable.
How much custody did they?
2
serve?
years. 2 years for the 498 A, my lord.
No, how much time they had remained in custody? Okay.
तो जगमत में कहीं कहीं आया नहीं है आपका भी थी
बताइए कितना दिन कस्टडी में रहे हैं
तो कहीं है नहीं हाउ मच ही वाज इन कस्टडी
कस्टडी इज इम्पोर्टेंट
हाँ पता करना होगा कहीं है नहीं इसलिए आई इस केस में लॉ
It does not say that it is mandatory to vote for it. This judgment does not say. It says that it has to take the entire facts and circumstances. And the learned court, has cited some satisfaction as to why these persons should be left on probation.
लेकिन एक भी कंडीशन को नहीं देखा गया
What
है।
condition? Expedient word ने use किया तो हम
नहीं उसके लिए नहीं बोल रहे हैं। उसमें लिखा है कैरेक्टर ऑफ द
Character, क्या character matrimonial dispute में क्या character?
ये भी सेम है।
Is there any previous conviction?
ये
Is there any previous conviction?
उसका कुछ भी रिपोर्ट नहीं मंगाया गया
क्या
मैंने।
मंगाना है? आप
एजम्पशन पर
आप वाइफ है तो आपको पता होना चाहिए ना।
कैसे होंगे वो इसमें तो कोर्ट को देखना है ना माय लॉर्ड।
That's right. You see, in the trial court judgment, is it mentioned that he has a criminal antecedent?
कहीं रिपोर्ट मंगाया नहीं गया है। रिपोर्ट नहीं मंगाया
कुछ नहीं और
लेकिन प्रोविजन तो फॉलो करना ही पड़ेगा
There is
मान
no
लो।
evidence with regard to previous conviction even as
लेकिन
per the trial
रिपोर्ट आज मंगाया जाएगा तभी तो रिपोर्ट केवल इसके लिए नहीं माय लॉर्ड उसका क्या
trial court judgment has recorded that there is no evidence regarding any previous conviction. So what else?
माय लॉर्ड क्रिमिनल केस चल रहा है उसी में फिर से शादी कर ली।
अभी हो गया?
शादी भी कर ली है
शादी भी किस
कर ली
शादी
है
में भी आपको उसी कारण से मिला। मेरा जो यही था ग्राउंड था कि मेंटेन नहीं करते हैं टॉर्चर करते हैं उसी ग्राउंड में हमको डाइवोर्स मिला।
That's right, but ultimately you are now married.
मैरिज नहीं मान लो लेकिन प्रोविजन तो ऑनरेबल सुप्रीम कोर्ट यही बोल रहे हैं कि जो कंडीशन है कुछ भी तो फॉलो होना चाहिए कुछ भी फॉलो नहीं हुआ है तो रिमांड होना चाहिए मान
हम एक चीज कह रहे हैं
आज इनका जो दूसरा केस है
दिस फॉल्स एंड fabricated case filed by this lady Milord. Why Milord?
Do you have to say anything on the point where that he has raised?
I'm coming to that. Can we have a look to Milord? Miscellaneous case number 77 2006 परिवार संख्या 665 2027 6 इतना को है ये जो है पेज नंबर लोअर कोर्ट का रिकॉर्ड है जिसमें I have filed before this case.
No, we are not concerned with that.
Can we have a look?
You just tell us. He has raised the point of Section 4 of Probation of Offenders Act. He said that the required condition has not been satisfied. Do you have anything to say on that?
हाँ पर उस पर तो हम कुछ नहीं कहेंगे लेकिन इतना जरूर कहेंगे एक चीज हम कहेंगे
You are also challenging this order.
कन्विक्शन को चैलेंज की
कन्विक्शन को चैलेंज की है कि ऑल केसेस फाइल्ड बाय दिस पिटिशन फॉल्स एंड फैब्रिकेटेड व्हाई आई एम सेइंग कि देयर इज
state has to say on Section 4.
Lord, the rightly we don't have given the meaning.
हाँ
has
Right.
given some
Yes,
reasons.
reason, yes.
हाँ इसमें
Now let
यही
us
है
see what you have to say against the
हाँ दिस इज कहते हैं कि इनका हम जो केस फाइल किए हैं
You see, don't tell me the stories. You just refer to the impugned order.
एकदम
Impugned order के बाहर कुछ नहीं देखना.
हाँ इम्प्यूग्ड ऑर्डर ही है कि कहती हैं कि हमको मार पीट के घर से निकाल दिया मार पीट किया है कोई इंजुरी नहीं है
Injury जरूरी है.
कौन सी यदि कहती हैं कि मारपीट की जरूरी है कोई इंजरी नहीं है मलेरिया इनको हुआ है शी हैज बीन हॉस्पिटलाइज्ड इन बनारस
The first point against conviction is that there is no injury.
नो इंजुरी और शी वाज एडमिटेड इन बनारस हॉस्पिटल घटना कहती है उसके कई महीना के बाद बनारस में होती है और उनको मलेरिया का उनको ये होता है सिम्टम्स
Don't try to link both them.
हाँ, तो इनका मारपीट का जो भी है कि मारा पीटा घर से निकाल दिया
Assault
हाँ
was not accompanied with any injury.
हाँ which is डॉक्टर संजय कुमार जी वाराणसी हॉस्पिटल मेडिकल रिपोर्ट 30/8/2006 को तैयार किया है दैट इज
We will not reappreciate the evidences. You just tell us what is the perversity in both the orders.
हाँ विदाउट करनी है मिलो मैंने ये भी किया है कि फ्रॉम द पेरूजल ऑफ जजमेंट ऑफ प्रिंसिपल जज फैमिली कोर्ट इतना मिलो कि इट हैज बीन रेफर्ड दैट सीएम का कहाँ है
You see, we will not see the other orders passed by CJN court. We will not see those orders. We will see only the orders passed by the trial court and the appellate.
The trial court has passed order not in a right view. He has taken Milord. He has not considered that lady was injured या वो she was in hospitalized due to malaria and she is saying कि हमको मार पीट के घर से निकाल दिया कहीं कुछ but इसी पर इनका केस that should be रिपोर्ट केवल फीवर का किया गया है दवाई नहीं दिया गया मारपीट का कोई दवा नहीं है अंकित नहीं है मलेरिया पाया गया इट इज अ फॉल्स एंड फैब्रिकेटेड केस she has filed in ground Milord I have taken Milord Para 15 Milord ki Gulshan Seri, this petitioner has divorced her husband. She has again married by another husband and she is living with family. She was hospitalized in the hospital of Sanjay Kumar, far away from this place of occurrence, Garhwa, to Varanasi. Pathology report, she is suffering from malaria, medicine and also given to the doctor. It means all false and fabricated case has been filed. All record is there. It seems all Milord case manufactured by his family members only to getting divorced her husband and have decided to perform her marriage another man and is living hospitality with the इसका हमारा भी है तो मैरिज की है कलकत्ता में उसका भी आ गया है सब इसमें एक चीज हमारा वही है कि परवेज आलम एक्यूज पर्सन मिलॉर्ड हस्बैंड ऑफ द पिटिशनर मिलॉर्ड earlier filed a complaint case being 666/2004 which has not been considered by London. उस केस में 107 कर दिए हैं कोर्ट ने कर दिया कि 107 ट्रीट करो
That's all.
One thing, my lord.
Gulshan Shiri is the husband.
Gulshan Shiri is wife.
Gulshan Shiri is wife. Yes.
Parvez Alam is husband. All family members have been implicated.
His husband. And what are all others? What is the third
All of
case?
the family members
Where
one.
is the third case? Basuruddin Khan and others?
Hmm.
Who are they?
Their family members.
Family means you have to tell us,
हाँ,
mother-in-law,
yes.
mother-in-law.
हाँ, यही है बसरुद्दीन खान उनके फादर हैं परवेज खान के, जहाना बीबी उनकी वाइफ है, बसरुद्दीन खान की, आलिमा बीबी सन ऑफ लतीफ खान जी. Aged about 17 years, she has implicated me.
परवेज आलम क्या बोले?
परवेज आलम ये हस्बैंड है,
ये जहानादा बीबी
वाइफ ऑफ माँ है इनकी परवेज आलम की, बस वो बूढ़ी औरत 70 साल की. लतीफ खान के बेटा है, बसरुद्दीन खान के जो है
is brother of father, right? So joint family थे?
हाँ.
So 1267 is here. दो केस है, तीन केस है?
2 केस. मतलब लास्टली माय लॉर्ड 2017 में जजमेंट हुआ था, ये लोग कोई बॉन्ड नहीं भरे, कुछ नहीं
आप
किया,
बॉन्ड भी नहीं भरे?
कुछ नहीं, तो फ्रस्ट्रेट कर दिए हैं वो पूरा प्रोविजन को जो उनको
उसके
benefit
बाद हम चले आए उसको.
बॉन्ड नहीं भरे तो आप प्रोसीड नहीं किया?
हाँ,
कुछ नहीं किया.
The court will proceed accordingly. Stay है यहाँ से. Stay है.
नहीं स्टे नहीं है.
वही तो बोल रहे हैं, फ्रस्ट्रेट खुद फ्रस्ट्रेट कर चुके
They
हैं,
have
जो इनको बेनिफिट मिला था वो खुद फ्रस्ट्रेट कर चुके हैं, अब इनको बेनिफिट कैसे मिलेगा?
बेनिफिटेड हम तो कहते हैं कि फॉल्स एंड फैब्रिकेटेड केस तो कुछ है नहीं है आपके केस में.
कन्विक्शन चैलेंज किए थे,
कन्विक्शन का चैलेंज उसमें आया हुआ है.
प्रोविजन ऑफ ऑफेंडेड एक्ट का प्रोविजन का बेनिफिट को नहीं चैलेंज किए थे, अब फ्रस्ट्रेट हो गया वो जो बेनिफिट उनको मिला था.
Yes, state. Would you say on this revision of accused verdicts?
The division of the after considering the entire evidences, Lord, rightly been convicted, Lord, and so far
What
the
will happen if they do not furnish the provision of offenders act bond?
Lord, the provision of offenders as bond has been violated, Lord.
What is the consequence?
The consequence, Lord,
What is the consequence of not furnishing the bond?
let me examine.
इसमें
You
दिया
have
हुआ
to examine that.
है सेक्शन कोड में
You're the senior most criminal practitioner of this bar. You want to say you want to examine it? What is the consequence? बताइए.
Yeah.
Yes, what is the consequence?
इसमें ये लिखा हुआ है कि when called upon during such period not exceeding 3 years the court may direct and in the meantime to keep the peace and with good behavior.
What is the consequence of violation of this order? Compensation paid?
नहीं, कुछ नहीं. इसमें लिखा to appear and receive sentence when called upon during such period.
What is the
This
consequence
is
of
the benefit given, Lord, in case, Lord, the sentence is, Lord, modified to, and if he has not executed that, Lord, so, Lord, the sentence which has been passed, he has to suffer for, he has to face that, Lord, sentence part, Lord. If has, because there is a provision, Lord, if, Lord, the provisions of is Lord, violated, and it is not, and the same is reported when it is only the suspension of the sentence, Lord, and the on the period during the period of provision. If he is not followed the condition of provision, my lord, then he has to, my lord, face the entire, my lord, sentence.
They were directed to appear before the learned court below within 1 month to do the needful. They have not yet appeared, that is why the compliance has not been done. इस ऑर्डर को कंप्लाई करने के लिए हम आपको 15 दिन का टाइम देते हैं, बाकी कुछ that would be the best. जो भी ये कंप्लाई तो करना पड़ेगा ना.
हमारा तो वही है कि इनका जो केसेज हुआ है, false and fabricated case has been filed according to their own merit of the case, my lord.
You are saying false and fabricated, but you are not showing any perversity in the orders. Your stories will not serve the purpose.
Perversity.
It is criminal revision number 1524 of 2017 with
इसे पैरा सेक्शन 9 के ऊपर देख लिया जाए.
क्या चीज देखते हैं?
इसमें तो वही बोल रहा है कि बॉन्ड का कंडीशन नहीं फॉलो करने से वारंट नहीं.
कंडीशन नहीं फॉलो करने. They have not furnished the bond also.
तो और ज्यादा वायलेशन कर दिया.
They were directed to appear before the learned court below to do the needful. 1 month's time was granted to them to do the needful.
तो पर्पस देखिए माय लॉर्ड, नेक्स्ट 3 years, नेक्स्ट 3 years, तो अब तो हो गया.
What were you doing? 2017 this matter has remained pending. What were you doing? You are so much concerned with
हम तो उस ऑर्डर को प्रोविजन ऑफ ऑफेंडर एक्ट का बेनिफिट को ही चैलेंज कर दिए थे, इसलिए हम उसके लिए हम एप्लीकेशन नहीं दे सकते.
That is why the order.
पर्पस को भी देख लिया जाए. एक्ट का पर्पस है कि नेक्स्ट 3 years. अब नेक्स्ट 3 years तो वो तो पर्पसलेस हो गया. अब तो ये तो माने इसका कोई मीनिंगलेस होगा. बॉन्ड भरने का मीनिंगलेस हो गया. बॉन्ड भरना मीनिंगलेस हो गया.
ऑल आया. उसी में तो हम कह रहे हैं कि जो हम केस किए हैं उसको
पर्पस ही खत्म हो गया इस एक्ट का.
आपके चल.
हम तो उसको चैलेंज किए थे.
जल्दी से करना चाहिए था.
हम चैलेंज तो तुरंत कर दिए.
मेंशन तो करते नहीं है, कोई मतलब ही नहीं है. केस अब टेकअप होता है, टाइम लेने के अलावा कोई काम नहीं है. ट्रेन टू टेक टाइम. एक्सपर्टीज टाइम लेने. Criminal Division number 1524 of 2017 with Criminal Division number 1262 of 2017. Both these criminal division applications arise out of the common order, common judgment passed in the common judgment dated 27th of July 2017, passed in criminal appeal number 18 of 2012. The petitioner in criminal division number 1524 of 2017 is the complainant, is the victim of the case, and is wife of Parvez Alam, who is petitioner number 2 in criminal division number 1262 of 2017. Petitioner number 1 and 3 in criminal division number 1262 of 2017 are the father-in-law and mother-in-law respectively of the petitioner in criminal division number 1524 of 2017. So far as petition number 4 in criminal division number 1262 of 2017 is concerned, he is the uncle of, he is the brother of petitioner number 1 in criminal division number 1262 of 2017. Right? The learned counsel appearing on behalf of the that the petitioners are victim of false case lodged by the complainant. He has submitted that the learned court below has not properly considered the materials on record while upholding the conviction of the petitioners. The learned counsel has submitted that though the complainant has alleged that she was assaulted and was thrown out of her matrimonial home, but no injury report has been produced before the learned court below to show that she suffered any injury. Rather, the report of the doctor showed that she was suffering from malaria. The learned counsel submits that the order of conviction affirmed by the appellate court calls for interference in revision. The learned counsel appearing on behalf of the petitioner in criminal revision number 1524 of 2017 has submitted that the modification of sentence by the appellate court and directing the convicts to furnish bond under section 4 of the Probation of Offenders Act suffers from illegality inasmuch as no report from the probation officer was called for in terms of section 4(2) of the Probation of Offenders Act. The learned counsel has submitted that the condition precedent that he has submitted that otherwise also the condition precedent for modifying the sentence in the manner it has been done by the appellate court has not been satisfied, and therefore the enjoined order calls for interference. The learned counsel has also submitted that the order passed by the appellate court has not been satisfied inasmuch as the required bond has not been furnished by the convicts. And the entire purpose of furnishing a bond under section 4 of the Probation of Offenders Act has been frustrated. He has relied upon a judgment passed by the Supreme Court in the case of Muhammad Hashim versus State of Gujarat, passed in Criminal Appeal number 1218 of 2016, dated 28th of November 2016, to submit that the word expedient has also been considered by the Honorable Supreme Court, and it has been held that while exercising power under section 4 of the Probation of Offenders Act, the nature of offence and the conditions incorporated therein are required to be considered. And only if the court forms an opinion that it is expedient to release the convicts on probation for good conduct, regard being had to the circumstances of the case, such order could have been passed. The learned counsel submits that the mandate of the provisions of provisions of the Probation of Offenders Act having not been followed, the impugned order modifying the sentence calls for interference by this court. The learned counsel's appeal appearing on behalf of opposite parties in each of the cases have opposed the prayer made in the respective case. The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that the impugned order passed by the appellate court does not call for any interference. He has submitted that both the courts below have considered the materials on record and have upheld the conviction, and so far as modification of sentence is concerned, the application of fine by the appellate court is reflected in the order. He has submitted that both the husband and wife have got remarried, and this aspect of the matter has also been considered by the learned appellate court while modifying the sentence. He has further submitted that since the lower court records have been called for in the present case, nothing is mentioned as to whether the order passed by the appellate court has been complied by the accused or not. He has submitted that in case it has not yet been complied, some time may be granted to comply the same, including the payment of compensation as directed by the learned appellate court, failing which the consequences may follow as per law. ठीक है, Mr. Pankaj Kumar? After hearing the learned counsel for the parties, this court finds that the matter arises out of a complaint filed. It was a complaint case? Complaint case? Arises out of a complaint case bearing number 778 of 2006 for alleged offence under section 498 capital A and 379/4 of the Indian Penal Code and section 3 of the Dowry Prohibition Act. The learned trial court has convicted all the accused persons in trial number 221 of 2012 upon perusal of the judgment passed by the learned trial court. It appears that the specific case of the complainant was that the complainant was married with Parvez Alam on 2/6/2006, and the alleged occurrence had taken place on 30/8/2006 and 2/9/2006, and the place of occurrence was the house of the accused persons, which was the matrimonial house of the complainant. It was alleged that the accused had started pressurizing the complainant for with demand of cash of ₹50,000, TV, fridge, cooler, and motorcycle from her father. And when the complainant refused to do so, they started beating her continuously, and she was subjected to live without food for many days. And she used to inform to her parents about the alleged torture. The matter was sought to be settled through village panchayat several times, but there was no change in behavior of the accused persons. And on 30/8/2006, all the accused persons overthrew the complainant by catching her hairs and assaulting her by fits and slaps. And thereafter, complainant suffered from fever, but the accused persons left her on open roof after assaulting her. Next morning, father of the complainant reached to the house of the complainant after getting information and brought her to her parental house with the help of the neighbors, and she was treated by a doctor. There she remained as indoor patient for 2 days. On 2/9/2006, when she recovered, she went to her matrimonial home, and again she was assaulted by the accused persons. And they pulled her down by force from the jeep, and they brought the complainant to their house and confined her in a room. It was her further case that in the night of 2/9/2006, accused tried to poison her. And upon raising alarm, she could rescue herself. It was also a case that her ornaments and valuables were taken away by the accused persons. The defense version was that it was a false implication of the accused persons, and they denied the allegations. Before the learned court below, altogether 3 witnesses were examined from the side of the complainant, and यहाँ से ले लीजिएगा 7, 8, 9, 10 and 13. 7 से लेकर 13 तक 1 line का sentences. The trial court considered the materials on record, and after scrutinizing the evidences, has recorded finding at paragraph number 27 onwards, and ultimately convicted all the accused persons and sentenced them accordingly. From the perusal of the order passed by the trial court, it has been recorded that no previous conviction of the convicts in any offence punishable under any law was brought on record before the learned court below, but the learned court refused to grant the benefit of Probation of Offenders Act by observing that the crime was committed against women. All the convicts were sentenced for a period of 2 also directed to undergo a sentence of 6 months rigorous imprisonment for offence punished by 973 of the Dowry Prohibition Act. The appellate court also scrutinized the evidences on record and upheld the conviction. And by passing the paragraph 6 in the following manner, so far as the sentence is concerned, the appellate court has modified the sentence by passing a recent order for modification of sentence in the following manner, with page number 47 in the document. This court finds that the learned appellate court has passed a recent order for the purposes of modification of sentence, taking into consideration the facts and circumstances of the case, and was of the view that the sending the convicts to jail would not meet the aims of justice, and also observed that the complainant as well as her husband have remarried and living separately, and they have no concern with each other. The learned court was also the view that some compensation was required to be paid, and directed for payment of compensation to the complainant amounting to rupees 25,000. The learned maintained the order of fine, maintained the order of fine. This court finds that so far as the argument of the learned counsel for the appellant of the convicts that no injury has been shown is concerned, this court is of the considered view that considering the nature of assault, the injury report, considering the nature of assault as alleged and the evidence of the victim having remained intact, merely because no specific injury has been found, the same is not a ground to interfere with the order of conviction which has been upheld by the appellate court. Absence of injury by itself does not make the improved orders perverse, considering the limited scope of interference by the revision courts. So far as the argument of the complainant by relying upon the judgment passed by the Supreme Court in the case of Mohammed Hakim versus State of UP is concerned, this court is of the considered view that the appellate court has cited reasons for modifying the sentence, and the law laid down by the Honorable Supreme Court has not been violated in the present case. इनका जरा कस्टडी देख के बताएंगे ना, इसमें मिनिमम सेंटेंस है ना, वो कौन कौन डॉक्टर बताइए, कस्टडी देख के बताइए। Dowry Prohibition Act is an act of 1961. 1961? 1961? नहीं पता. And Probation of Offenders Act is an act of
58, 1958.
Just tell us what is the period?
Right, just this blood Aliburi has surrendered.
What is the period of custody? You do not know. No idea.
नहीं, उनको शायद तुरंत बेल मिल गया था शायद, कस्टडी नहीं हुआ.
minimum sentence पे probation of offenders पे मेरा judgment हम लोग पास किए हैं ना तो council को कोई लेना देना ही नहीं ना तो environment को कोई लेना देना है ना state को कोई लेना देना है. There is a conviction under section 384. Conviction under section 384.
3, इसमें 3.
3 has minimum sentence. 4 has minimum sentence. What is the date of offense? What is the date of offense?
38/2006. 29/2006.
Read section 3. Dowry promotion. You don't get bail also. Mr. Pankaj Kumar, you just let me know. In the case of Probation of Offenders Act, can the benefit be extended in a case where there is a minimum sentence prescribed?
My lord has not extended the benefit by giving a special reason.
Special reason has to be there, no?
Yes.
But the appellate court has not assigned any special reason. Has it? This. Is it not a part of your duty to tell us that there is a minimum sentence?
Yes, sir. My lord has already decided in one case, my lord. Regarding
I have decided it, I remember I have decided.
in that case, my lord, I have also my lord assisted your lord. And do not recollect that
Judgment,
case.
I don't remember where it is. ऐसे है कि जो इनका सबमिशंस था वो सारा रिकॉर्ड कर दीजिएगा और इसको जो है आर्गुमेंट्स कंक्लूडेड पोस्ट फॉर जजमेंट ऑन फरवरी में कोई डेट फर्स्ट और आप वो जजमेंट
ये
मिनिमम सेंटेंस में आपको क्या बोलना है एक्यूज्ड
क्या बोलेंगे मिनिमम सेंटेंस पर जो लॉर्डशिप हैज डिसाइडेड इन वन केस
I might have decided that minimum sentence has to be given.
that
You
should
want
be
to go to
followed
jail?
that should be followed
It will be followed. Then you have to go to jail. Then you have to go to jail. As I remember, I have stated
There-
I held that
they are
minimum
more than
sentence-
70 years that's why my lord should
Who is more than 70
consider
years?
कि they
Who
are
is more than 70 years?
बसरुद्दीन है उसकी वाइफ है दोनों जो है
Mother-in-law and father-in-law.
मदर इन लॉ
What about this person, the brother of the father-in-law? Any specific allegation against him?
Common allegation है.
Common allegation, general allegation, omnibus. It is open to the council for the parties to file the written notes of argument within a period of 1 week. You file it, you have to see. You cannot pass on the
330 में जो पास
Sorry?
330 हाँ वही
Let's take it. I have taken
कोई obstruction also as a witness बात करने के लिए तैयार है मेरा एक सबमिशन है लॉर्डशिप।
आपके यहाँ क्या समझ?
नहीं, हम आपको नहीं आपके पास करना मीडिएटर जो होगा शुड बी एडवोकेट। वो अदरवाइज एडवोकेट जो होते हैं वो हमारा पर्सनल एक्सपीरियंस है, वो बहुत प्रेशर है और सही मीडिएशन हो नहीं पाता। इसलिए हम चाहते हैं जो मीडिएटर हो वो एडवोकेट हो।
आप बताइए किसको मीडिएटर?
नहीं, किसी को भी, उसमें हमारा कोई नहीं, बस एडवोकेट, बस इतना ही मेरा। नहीं, हमको पता नहीं है कौन कौन है, बस मेहनत नहीं केवल एडवोकेट से है तो ठीक रहता है। वो समझते भी हैं और लॉ भी समझते हैं, और अदर देन एडवोकेट हमारा पर्सनल एक्सपीरियंस नहीं ठीक रहता है, इसलिए हम सिर्फ चाहते हैं कि एडवोकेट रहे।
मीडिएटर का नाम इसमें है क्या? ये सब लीगल एड वो मीडिएटर्स का नाम इसमें लीगल एड काउंसिल्स का किसी एडवोकेट का
हाँ,
नाम
किसी भी।
बताइए, कौन है वहाँ पर मीडिएटर? इज देयर एनी नो?
I have been there for a commercial dispute. तो वहाँ पे एक chartered accountant थे. He had to resolve it.
Tribunal Division number 440 of 2017, counsel for the petitioner and the opposite parties. And the opposite party number 2 have taken instructions from the respective counsels and have submitted that the matter may be sent to Jharkhand State Legal Services Authority for mediation. The learned counsel for the opposite party number 2 has submitted that it would be better if the mediator is an advocate. Considering the aforesaid, they have also submitted that primarily the dispute revolves around quantum of maintenance.
One time for one time settle.
One time settle.
Quantum of maintenance by way of one time.
And another thing is स्त्री धन also. हाँ, इसलिए इसमें नहीं रहेगा तो नहीं घुसेंगे, आपके ऑर्डर पे नहीं रहेगा ना, तो फिर वो उसमें इंटर ही नहीं करेगा।
And other allied factors. Considering the submissions, let this matter be placed. Let the matter be sent for mediation before Jhalsa. The parties will appear before Jhalsa on, I'll give a date.
Yes. Yes. Next week, Wednesday, Thursday. Saturday. Saturday, हाँ, Friday, Thursday. कोई भी दिन, Thursday दे दिए ठीक है।
On next Thursday.
कितना तारीख दिया? 11.
On next Thursday at 11 a.m. upon their appearance, the learned secretary Jhalsa shall appoint a mediator, preferably an advocate, for resolution of dispute between the parties. Let a report of the mediator be furnished to this court by 8th of February 2022, post on time.
Problem.
Item 12, WPS 5114 of 2021.
Maybe. Not today, first time, but the interlocutory application being filed by us for amending the main petition challenging the final order during pendency of the writ application. The final order has been passed, and it same has been challenged by.
Final order means?
Final order, there was the direction of this honorable court to decide the case. It has been annexed. And it was not being followed, my lord, and the contempt proceeding has been initiated, my lord, and during pendency of contempt, the final order has been.
Where is that order by which the final order was to be passed?
I am not 3787.
No, where is the direction?
Direction. At the next 12.
So what was the writ petition?
A writ petition of consideration. 42 persons, my lord, were appointed SI, my lord. It has been challenged. Matter went up to the Supreme Court. He could not challenge, my lord, due to one case which was pending, my lord, though he has been appointed. Annexure 1 is the appointment letter initially, my lord. He has been appointed. Finally, he has been acquitted, my lord. The charge at that time he was minor. So he could not pursue that very case, my lord, the matter which went up to the Supreme Court.
And then thereafter the writ application has been challenged. Then there was the direction to consider the case, and it was not being considered. Thereafter, the contempt proceeding has been filed. Has been filed.
What is the prayer in the writ petition?
In this writ application.
Yes.
Yes,
What
madam.
is the prayer? This writ petition has been filed after the contempt case?
During the contempt.
No, during.
During the.
Yes.
What is the prayer in this writ?
Straight away I am reading.
No, reading means you have challenged some order?
Yes, madam.
Which order?
At page 13, 14 and 15.
Page 15.
Annexure 14 series at page 107.
107.
And thereafter 109 annexure 15.
107 is what?
10 the final order, it was not considered, my lord, the appointment.
Then now what will happen?
Thereafter, my lord, the 14 and 15. Thereafter, my lord, the writ application has been filed, direction was given. Then this writ application has been filed. Final order has been passed, my lord, challenging the interlocutory application. In which?
In this writ petition, a direction was given to pass a fresh order.
Yes.
Where is that?
Yes. Annexure 13?
No, not annexure.
No, annexure 13 at page 104. Yes.
During the pendency of this writ petition, any order was passed by this court upon the respondents to pass any order?
No. Annexure 13, the earlier order passed by this honorable court, my lord, at page 104.
This 7/3/2022 is an order passed pursuant to order passed in WPS number
1558 of
1558.
Yes.
That was the earlier writ petition, not thereafter.
There was the batch of.
Wait a second. After you are not able to clarify, let me.
Yes.
Thereafter, the contempt was preferred, and in reply to contempt, show cause was filed, and along with this show cause, this order was passed.
That's good.
The ADG Home Guard.
So where was the occasion to file the fresh writ petition? Why
Now
did
he
you
has
file
filed
the
a fresh
writ?
representation challenging challenging the earlier order passed by the commandant matter, by which he was terminated.
So it is related? Not related.
Both are related.
WPS number 5114 of 2014. This IA number 3787 of 2022. The learned counsel for the petitioner has submitted that a petition for amendment has been filed on account of subsequent development. He has submitted that during the pendency of this case, an order has been passed pursuant to order passing WPS number 1588 of 2014. The prayer sought for through amendment is related to the main relief as prayed for. Is there any appeal against this order? Considering the submissions made, the petitions, IA number 3787 of 2022 is hereby allowed. The counsel for the decision is directed to file an amended petition before this court by 19th of January. Supplementary counterclaim will be filed by 9th of February, post on 16th. Rejoinder, if any, by 15th February, post on 16th.
Item 13, CRNP 1511 of 2023.
Notice has been served.
I went.
It was locked. As OP number 2 has vacated. Who is OP number 2?
Mr. Rupesh Ranjan.
Where is he? He's your husband? You have any idea where is he?
Ma'am, I have sent to their Patna address also and Ranchi में उनके grandparents रहते हैं, उनके यहाँ भी मैंने भेज दिया है और WhatsApp में और email में भी मैंने भेज दिया है नोटिस, तो वो तो उनको तो मिल ही जाएगा मैम.
We do not know. You have to file an affidavit first in there. He has left that particular place. He is living in some other place. He is running away. Petitioner appears in person. As per the service report, the notice could not be served upon the opposite party number 2 on account of the and it has returned unserved by with a note that the OP number 2 has vacated the flat. The council for the petition submits that appropriate order be passed so that we may take steps for fresh service of notice and the present and current address of opposite party. How much time do you need?
Why not 1 or 2?
At his present and current address. मिल जाएगा? Let notice be let requisites be filed for fresh service of notice under through opposite party number 2 under ordinary process as well as a post by 12 of January 2023, post his case on 9th of February 23, awaiting service. This will be a petitioner appearing in person.
For admission item 14, WPC 7479 of 2013.
Made. Just since the time is very less, that's why I'm just giving the little background.
Affidavit has come.
Pardon me.
Affidavit has come.
Yes, affidavit has come. Affidavit has
You are
come.
appearing for
Lord, I am appearing for respondent number 5 RBI.
Reserve Bank.
you are filing
Yes.
and where is the money?
Money may not.
No, money can
Lord, this is
money
a
can.
matter.
Amalgamation of the cooperative.
My Lord, proposed amalgamation of cooperative society has been challenged.
Proposed amalgamation has
The
been.
cooperative
Yes,
bank.
Lord, the prayer made was challenging the letters.
The registrar
holding
had
meeting.
issued a letter directing the cooperative bank to hold a meeting for its merger with other similar cooperative banks. That was the direction. And according to the registrar, that direction was issued under Rule 39 of the cooperative rules. Well, that's the brief, which is the
Who
annexure.
are you?
Well, I am the member of the cooperative bank. Well, we are the basic member of those cooperative banks. Well, that's why we have come. That your direction is for the members to hold a meeting of members of the bank to hold a meeting for its amalgamation, and that direction was given under Section 30, Rule 39. My lord, we had come before your lordship, my lord, in view of the section 44AK that was introduced, my lord, long back in the year 1992. That says that in case of a bank, the approval of the Reserve Bank is essential.
Yes, what does Reserve Bank has to say?
Reserve Bank
They
has
say
said
that in absence of your approval, such direction.
The fight is between them. We
No,
have
fight
said
is between them, but they say that your approval was required.
we have given.
You have given the approval.
Yes.
So that point goes. What else?
no, that point is still there. Paragraph 16 of their affidavit, your lordship may kindly see.
It says what?
Of the Reserve Bank's affidavit.
Approval denied.
Yes. For other amalgamation, they have said.
Other amalgamation means what?
My lord, background, your lordship kindly recollect. There are 8 district level cooperative society.
You file your written submission. Say, pleading is complete.
Yes, pleading is complete. My lord, your lordship may
The
kindly
only thing
consider.
is, the correspondence affidavits, if any, may be shared with us.
You have filed any affidavit?
Yes, Lord, we have filed.
They
You
must have
share
also
it.
filed.
I have filed for the bank. I am for the bank.
Every
I have filed. I have written submission also prepared because encapsulating the entire
You are
total flow,
supporting the
etc.
petitioner, no?
Supporting the petition.
Your written submissions is same as that.
It
of
is
the
purely on law, menos no facts.
The correspondence affidavit. That's the
Yes.
Lord, I will, sir.
You are supporting the petitioner.
No, Lord, sir.
You are who are you?
I am respondent number 1 and 2, the registrar, who has passed the impugn order.
They are the authors
What
of
is
the
your
proposed.
case? What is your case? You have rightly issued the direction.
Yes,
The
Lord.
meeting did not take place thereafter. There is a stay order.
My lord, they have no jurisdiction. That's the
There is a
question.
stay
I
order.
want to know
facts,
whether the
not
order
on
has been complied or not complied.
No, there has been a meeting, still there has been. In spite of that, there has been a meeting, my lord, of the members of the bank, and they had decided not for merger, not for amalgamation.
If they have decided not for a merger,
Right.
not for amalgamation, then what survives in this?
The state is
Well,
forcefully getting it.
The state has to defend their order.
No, the point is that there was a direction to hold a meeting,
Yes,
right? You are agreed by such direction that no such direction
could have been given.
could have been given. Fair enough.
Yeah.
Now a meeting has already taken place, and they have decided not to merge.
Right.
That decision has become final. So what is your grievance now?
Well, that's why, my lord, now the writ has to be allowed.
It has to become infructuous. Because pursuant to the impugned orders,
Right.
that has taken its effect and meeting has convened and they have rejected.
Yes, the
Nothing
members.
survives.
No, even as per,
Yes, now the
as,
state. Yes.
as per Rule 39 of the Jharkhand Cooperative Society Rule 1959, even if they have rejected that, still if the registrar feel that the amalgamation is unnecessary, he can issue direction for amalgamation. So as evoking that, yes, Lordship, that step has been done, and we have issued a letter, but due to the stay given by the Honorable Court, that step has not been completed yet. That is under challenge.
So you have taken a decision that there has to be a meeting.
Yes, Lordship.
This is amalgamation for what?
Compulsory amalgamation.
This is amalgamation for what? Amalgamation with the main cooperative
With the Jharkhand State Cooperative Bank.
So you do not want this independent state-wise cooperative society.
Earlier there were
They are
total.
self-supporting or they are self-supporting cooperative society?
Yes.
Earlier there were eight district cooperative banks in the state of Jharkhand. A decision was taken for the better administration to amalgamate and get it into 2 tier from the 3 tier.
Three tier to 2.
So 3 tier to 2 tier. Out of the eight cooperative banks, 7 have already given consent and they were already amalgamated with the consent of the RBI.
This was the story of Dhanbad Central
Dhanbad
Cooperative.
Central Cooperative. Yes, Dhanbad Central
And
Cooperative.
the division bench judgment already, similar direction earlier has been set aside by the LPML 80 that order we have brought to your lordship notice. Order number 5 and 6 of this case, your lordship may kindly see. In this very case, that they had no authority at all.
And if they are aggrieved by this order, there is also a provision for appeal against that order.
No, now this petition is pending since 2013. So all if the basis of the order goes, everything goes, no? So cause of action, all subsequent orders we are not concerned. We are only concerned with that direction which is under challenge. We will not adjudicate upon any other orders which are not impugned in this case.
UDC has perhaps passed an order. UDC will be going into the issue of alternative remedy. UDC will sought for assistance.
Nothing is on the record. Please don't make any oral statement without bringing the facts on the record.
It has been mentioned that the sources of argument will also include the point of alternative remedy which has been raised by the state.
Well, your lordship, can you see the order number 5 and 6? 5 initial order, directing them, and then reiterating by order number 6.
That's right, but there is an order. You can't say that it is
No.
beyond the records.
No. He said that deputy commissioner has passed the order. I have objected to that. Order number 5 dated 25th of March 2021. The instant petition is filed under Article 26 of the Constitution of India, whereby and whereunder the decision of the state government dated 2/12/2013 for amalgamation of the Dhanbad Central Cooperative Bank Dhanbad with the Jharkhand State Cooperative Bank has been questioned on the ground of non-observance of the mandate as contained in under Section 44A(k) of the Jharkhand Cooperative Societies Act 1935. Mr. So-and-so learned counsel, assisted by Ms. So-and-so,
You formulate your question of law.
Very
You
well.
are on point of law, you formulate your
Mine.
I record it in the order. And here what the flaws.
फॉर्मुलेशन हो जाए
नहीं अब क्वेश्चन
बोलते हैं क्या 4:30 बज गया
हाँ फॉर्मुलेट करेंगे कर देंगे कोई दिक्कत नहीं
फॉर्मुलेशन हो जाए तो हम लोग रेडी होके आएंगे
अब काहे के लिए they are the young people, they may survive, but after 4:30 I am a man of 75 years, I cannot sustain the pressure. आप रह सकते हैं दिन भर
सर आप लोग
एनर्जी से कम है मेरे तक कोर्ट में मैं 2 में बैठ जाते वहां तो नहीं बोलते हैं कि यू कैन नॉट सस्टेन यहाँ का हवा पानी फर्क है
नहीं of course outside that courtroom but on other meeting I
कोर्ट में भी बैठ रहे हैं प्लीज डोंट
नहीं 4:30 के बाद नहीं रुकते
4:30 के बाद कुछ नहीं बोलेंगे but you formulate your point and
I will
नहीं फर्निश करिएगा तो हम बस ऑल्टरनेटिव कमिटी में चलेंगे
नहीं जी नहीं ठीक है अल्टरनेट राइज नहीं करता क्वेश्चन दे हैव नो जुरिस्डिक्शन अरे सिंपल इंडिकेशन यही कर देते हैं क्वेश्चन फ्रेम करना है रूल 39 में हम बता देंगे अभी इंडिकेट कर देते हैं ये लोग जो ऐसा बोले हैं कि देयर मस्ट बी अ डिसीजन ऑफ द अथॉरिटी हियर देयर इज नो डिसीजन ऑफ द अथॉरिटी देयर इज अ डायरेक्शन टू होल्ड द मीटिंग टू फॉर मर्जर उसके बाद में डिसीजन होगा इन कंप्लायंस ऑफ द कंडीशन मेंशन इन द रूल और एंड सेक्शन 44A(k) ऐसे केवल रूल इज बियॉन्ड द
10 years
एनर्जी पूरा है अभी सर
अब 10 साल तो हुजूर यहाँ हो गया पूरा प्लीडिंग कंप्लीट है Nonetheless, there are judgments. Lordship will recollect that after the completion of pleading, traveling for such a long time.
No, we are. You see, the point is that if there is a question of law, we will surely.
right.
But then that question of law has to be
decided. Yes, couched in a proper word.
Everybody to notice to that.
Yes, that has to be couched in a proper way.
Anybody by surprise.
Yes, certainly that has to be couched in a proper legal ways.
Counsel for the parties are present. The learned counsel, the learned senior counsel for the petitioner submits that there are no disputed facts involved in the present case and pure question of law is involved regarding interpretation of the provisions of Jharkhand State Cooperative Societies Act and the rules framed thereunder as made applicable to the cooperative banks in the state of Jharkhand. The convenience compilation सब मिल के देंगे कॉमन कि क्या करना
चार पिटिशनर जो सपोर्ट कर रहे हैं
ठीक आप लोग एक कॉमन कन्वीनियंस कंपाइलेशन दे दीजिए
उसमें आपका
Should
जो
comprise
written
of
note
every-
होगा उसी में डाल. Council for the party shall jointly file a convenience compilation and giving the list of dates and the synopsis of their respective case, a copy of the provisions of law which they are relying upon, and formulate the points of law. The needful be done by next Thursday.
Well, one request, my lord, your lordship kindly permit. My lord, the section 44AK, my lord, it was introduced earlier. But now the latest position in the state of Jharkhand in 2015, it is of 2013. We have already raised the
We will
point.
be governed by 2013.
2000, but there has been amendment in the statute in that very provision in 2015, because your lordship's order will be in the light of the present legal
No,
position.
The order will be in the light of the impugned order as it was passed then.
ठीक ना, हम केवल यही इंडिकेट
We
करना
will
चाह रहे
not
थे.
take care of subsequent changes of law
statute-
unless it has been made retrospective.
नहीं,
Because there is only two issues. The rule of 1959 that
Formulate करने बोलते तो 4:30 बजे.
नहीं, ठीक है,
और
ठीक
ऐसे
है.
लेक्चर देने बोले तो 5 बज जाने में
और
कुछ
जो एक्ट है वो तो 1982 का जिसमें
Who is this on next time?
Just a small. I just
My
missed.
lord, one minute, so that my lord, compilation has also been list of the.
एक और हफ्ता चाहिए.
हाँ, एक हफ्ता और.
19.
I just missed that 231 restoration,
final disposal.
one restoration application of the CMP, my lord. I just praying for coming Friday, my lord.
हाँ, भूल गई है कोर्ट का क्या सिस्टम.
नहीं, actually 2:30 बजे मिस कर गया 2 मिनट.
यहाँ पे मेंशन स्लिप कौन अलाउ करता? हम नहीं अलाउ
अच्छा,
करते.
ठीक है, court master साहब.
Court master is
नहीं.
authorized to allow all the mention slip.
Great.
And for rejection, he has to take my order.
Yes.
All right.